May it please the Court, Beverly Pohl and Christina Leem for Vital Pharmaceuticals. I'd like to reserve 3 minutes for rebuttal. This is a pretty simple question of law in this case, and that is whether a party who seeks damages after a wrongful injunction may do so when there has been no bond posted for the injunction. We think the answer is plainly no. And the trial court, in allowing entitlement to these damages, never made any analysis. The entitlement order itself is a one-word order that says granted. And the court very carefully refused to reconsider the issue either before the hearing on the amount or at the hearing of the amount. So we don't have the benefit of any analysis from the trial court, but we do have the benefit of substantial case law on this issue, which all favors Vital Pharmaceuticals, which we call VPX. It started with Parker Tampa 2, where the Florida Supreme Court, in a rather lengthy decision, decided to adopt the majority rule and held unequivocally that the damages for a wrongful injunction are capped at the amount of the bond. And that makes sense because that is the purpose of the bond. The purpose of the bond is to provide a fund of money for an enjoined party that was wrongfully enjoined. This case presents a little different question. What if there is no bond? But of course there must be a bond because Rule 1.610 requires a bond, and the statute requires a bond, 6007, and even the non-compete statute requires a bond since 1996.
But what's missing from both the rule and the statute is whose burden it is to ensure that the bond is imposed per the rule and the statute. So here, it was obviously your client as the plaintiff that was seeking the injunction. Should it have been your client's burden to say, Judge, we recognize what the rule and the statute say, and therefore, as a condition of us requesting this bond, we have taken upon ourselves to offer whatever bond is you deem reasonable, and make sure that the judge made a ruling on that.
I think both sides have a burden because the bond serves to protect both sides, as the court noted in Parker Tampa 2. Arguably, an injunction issued without a bond is ineffective. And it was argued by the appellees in this case that the bond was facially deficient, and that's why it should be dissolved.
So is the party moving for the bond and wanting the bond? Shouldn't it be the plaintiff's burden to say, Judge, you've given us what we wanted, but it's ineffective. You need to impose a bond on us?
Well, arguably both sides have an interest because one could say without a bond, the injunction is simply unenforceable because that's an essential element of what's required by Section 542.335. This is a non-compete case. You have to have a bond. On the other hand, the enjoined party should want a bond because, as Parker Tampa 2 said, the bond sets the upper limit for the damages that can be recovered if the injunction was found to be wrongful. So the enjoined party wants a bond so they can recover if the injunction is dissolved. And the party moving for the injunction wants the bond because it wants to cap its liability.
Well, we can understand why everybody might want the bond, but the question was who has the burden to make sure that the bond is ordered?
I don't believe that anybody's really said who has the burden, but who suffers if there's no bond? And the movement suffers because the courts have said that an injunction with no bond is not even an enforceable injunction. And what have courts said since Parker Tampa 2? This court in Ross, well, let's start with the 5th DCA. 2 years after Parker Tampa 2, I believe it was. I'm not sure about the year, but Shea, the 5th DCA, said the bond is the sole source of recovery for damages. Then in 1991, this court in Ross said if it is later determined that an injunction was wrongfully obtained, there can be no damages because there was no bond required. That's a pretty powerful statement. It's this court, and that's exactly the situation we have in this case. And then later, in a more recent case, Highway 46, the 5th DCA again said, if there is no bond, the enjoined party is without recourse. Now, there is one subsequent Florida Supreme Court case, Provident versus City of Treasure Island, I think it is. And in that case, there was no bond. The injunction had been sought by a municipality, and the Florida Supreme Court carved out an exception to Parker Tampa 2 because no bond is required under the rule for a municipality or a state agent that goes in to get an injunction. So they said since it was legally permissible to have no bond, we're not going to say that you can have no damages for a wrongful injunction. And even that was a divided opinion. Justice Anstead took issue with it very heavily. But certainly no case since Parker Tampa 2 in the 80s has ever held that in the absence of a bond, you can have damages for a wrongful injunction. There's no authority for that, and all of the authority that I've stated here, these three cases, Ross, Shea, and Highway 46, are to the contrary and support our position.
But if you're not asking for a bond, you're basically asking the court to enter an unenforceable bond, aren't you?
I'm sorry.
If you're not asking for a bond, you're asking the court to enter an unenforceable injunction, aren't you?
Well, I think the presumption is that there will be a subsequent bond hearing, and upon the motion to dissolve, both parties recognized that there had to be a bond, and both parties submitted proposed orders suggesting what they thought a reasonable bond might be. But that never occurred because the injunction itself was dissolved. So it never really happened. But that it happens often that an injunction may be entered and the order itself may say, we're going to have a subsequent hearing to determine the amount of the bond. But here, I think we're flat up against Parker Tampa 2 saying that the injunction damage, or the damages for a wrongful injunction, are capped at the amount of the bond, and no authority whatsoever, not a shred of authority, in fact, from any jurisdiction, saying that these damages can be awarded in the absence of a bond. Here, it's just a windfall to the appellees in this case.
Well, on the facts, is there anything to suggest in this record that what they ultimately recovered as their damages for the wrongful issuance of the bond is anything other than what the bond would have been set at had we had such a hearing?
Well, one cannot know because they sought a bond in excess of $800,000. So, which included their anticipated lost income. But at the actual hearing on damages, they didn't even assert that they had lost any income. And the only damages they sought were for the attorney's fees. So
Those are tangible, hard costs for which there was testimony to support it. So although there may have been error in not following the statute in setting the bond, is it harmless error to say that had the error been corrected and a bond been set, at a minimum it would have said, pay for their fees, and the fees were in fact determined to be a reasonable amount.
I don't think this court can presume what the bond would have been. There was dramatic disagreement between the amount sought by the two parties, and so I can't imagine that a party seeking in excess of $800,000 would have been comfortable with saying the bond's going to be $38,000. But you have to go back to section 6007, and the language of that says that in injunction actions on dissolution, the court may hear evidence and assess damages to which a defendant may be entitled under any injunction bond. This statute itself presumes that a bond exists because, you know why? Because it's required under the rule governing injunctions. And you have to look back at these three cases, all of which say no bond, no damages. And if you think there may be some basis to award damages, then you have to move forward to the hearing itself, and the absolute lack of any evidence that these appellees sustained any damages. The evidence is that there's no retainer agreement with any lawyer. There's no testimony or evidence of any kind that they had personal liability for attorney's fees, that they paid any fees or that they owed any fees in the future. The only evidence is to the contrary, that ProSups paid the fee. ProSups has a retainer agreement with Carlton Fields. Mr. Guadagno testified in his deposition, and that's Exhibit 2 in the record, that he had no liability for fees, and there's nothing affirmatively from Mr. Humphreys that he had any liability. So even if they could seek these attorney's fees as damages, the evidence is legally insufficient to support it, because this is a damages case, not a fee-shifting case. And so if they have to prove damages, they have to prove that they had individual expenditures, that they sustained damages, or at the least that they had some obligation to pay for those fees at some point in the future. And the evidence completely is silent as to that.
Well, ProSups is the real party in interest. I mean, we allow insurance companies to recover fees, even though their insureds are perhaps the nominal parties.
Well, ProSups is not the real party in interest. This is a this issue here is whether two former employees should be enjoined under the terms of their employment agreements. So ProSups is not the real party in interest. It's the former employees of VPX. So even though ProSups gratuitously offered to pay, this is not a situation like the insurance example that you gave, where we're talking about a fee shifting statute where it doesn't really matter who paid the initial fees, but you can still recover them at the end. This is not just a prevailing party fee statute. This is a damages statute, and that's an important, distinct analysis because these two individuals had to prove that they sustained damages.
My recollection is ProSups was a defendant in the case only as a tortious interference defendant for having allegedly misappropriated these employees, correct?
I don't remember exactly what counts there were against ProSups. They were a defendant in the case, no question about it, but
Obviously, they can't be a party to a breach of employment agreement to which they're not a party. They can only be liable for the tort of the interfering with that contract, correct?
That's right.
Allegedly.
That's right. So this injunction is based on the contract itself, and the injunction was denied as to all of the other defendants, just these two individuals. So that's the argument. There is absolutely no authority for, is this 3 on my main time or on
Main time.
Main time, okay.
Well, when the yellow light goes on, you're into your rebuttal time.
Okay. No authority supporting the notion that people can just have no bond and yet seek damages for a wrongful injunction. You ask who the burden is on. Well, the burden is on whoever seeks to benefit from the bond. It's very risky to have no bond, because if you're the movant, if you want the injunction and you have no bond, there's plenty of case law saying it's an unenforceable injunction, so you haven't really achieved anything. If you're the enjoined party and you have no bond, you have no fund of money under this court's Ross case from which to seek damages if you prove that you were wrongfully enjoined. So both sides have an interest in it, and the court, frankly, should have an interest in setting a bond with an injunction to ensure that it meets the standards of Rule 1.610 and that it's an enforceable injunction.
Now you're into your rebuttal time if you want to wrap up.
Okay. I didn't mention one thing, which was the appellees made an alternative argument that they could recover these fees under their contract or even under the statute governing non-competes. That makes no sense because both of those are prevailing party provisions and only would be applicable at the end of the case, not at this stage of the case. So we are solely looking at Section 60.07 and whether damages can be awarded for a wrongful injunction in the absence of a bond. And all of the authority and the best analysis says that it cannot. I'll reserve my remaining time.
Thank you. We'll start off with the first question that I asked Ms. Pohl, which is who has the burden to ensure that the bond is entered pursuant to the rule in the statute?
Your Honor, I'd refer the court to 2 cases in particular. The first case is this court's case in Net First National Bank. The facts in that case are strikingly similar to the facts here. There was an initial injunction hearing. Parties decided on the merits of the injunction but didn't mention the bond amount. At the end of the hearing, the trial court reserved ruling and then entered the injunction setting an arbitrary nominal amount later on without affording any of the parties an evidentiary ruling as to the bond amount. This court held that it wouldn't be limited to that arbitrary bond amount because it was the enjoining party's burden to afford the enjoined party an evidentiary ruling. I'd also refer the court to the second case, which is the second DCA's case, Advantage Digital. There, the court said it was the trial court's burden to make sure that the enjoined party was given the opportunity to prove its damages. I think that settles the question, in addition to the language of the rule, which obviously puts the burden on the moving party to make sure there's a bond in place if it wants to have an enforceable injunction. Now I'll continue to address the entitlement issue at large. I think they're making 2 arguments as to entitlement. First argument is predicated on the interpretation of Parker Tampa 2, the Florida Supreme Court case that espoused a general rule where damages would be capped at the bond amount. Now, it didn't envision a case where there was no bond. It didn't envision a case where the enjoined party was prevented from putting forth evidence as to foreseeable damages. Cases following Parker Tampa 2, have all said there's a conundrum that was left unaddressed by the Florida Supreme Court. This court in the Andrus case in 2014 stated the same. There, Judge May said there is a second exception to the general rule, and that exception kicks in where the enjoined party was prevented or simply not afforded the opportunity to present evidence on damages. And in those cases, we're not going to cap the damages amount to any arbitrary sum or any nominal sum. We're going to allow the enjoined party to recover the full extent of the damages that it suffered. I would contend that...
But isn't that a situation where the bond amount's inadequate?
It's not inadequate. There's a difference
but the
between...
situation you just described would be a situation where the bond amount's inadequate, and Judge May is saying you're not capped at that bond amount. You can go over under certain circumstances. In this case, there is no bond.
Yes.
So how does that case apply here?
Well, it's not just a matter of inadequacy. If there was inadequacy coupled with an evidentiary hearing as to that total figure, you would be stuck under Parker Tampa 2. But where that inadequate bond was the product of a lack of an evidentiary hearing, as in the enjoined party was deprived of the due process of proving its damages before the injunction was entered, then we're not going to cap the damages at any amount. Essentially, the arbitrary bond in those cases it's tantamount to no bond at all, as we've argued. Just a number plucked out of thin air by the trial court after or before its entry of the injunction. And so I understand there's sort of a difference between a nominal arbitrary bond amount and no bond, but in the case where the enjoined party was still deprived of its ability to project its foreseeable damages, there is no difference. I contend that's the case here. That's the case here. The parties were party to that initial injunction hearing, and they were not afforded the opportunity to present evidence on damages.
But I suppose the fear that we would have, or the slippery slope fear that we would have, is that defendants, or I should say the non-movement on an injunction, can play a gotcha role. That is, they know that they want a bond because they want to be able to secure their damages, but they know that the injunction's ineffective without the bond. So it's like taking the cap off the bottle, and as Ms. Pohl pointed out, your claim was not for $38,000, it was for $800,000, and the judge, for whatever reason, decided you're only getting your fees. But it could have gone the other way.
Those affidavits, the $800,000 figure was in the event that the injunction was ratified as opposed to dissolved. So in that case, we would imagine a situation where the injunction was in place throughout the course of litigation, which has now spanned 3 to 4 years. At that point, the employees would have been deprived of being able to work for their employer or for any employer affiliated with VPX, the appellant here. So that $800,000 figure encompasses this bigger picture. At the end of the day, we only sought to recover the damages that were incurred by dissolving the figure. And let me address the policy concern that you've raised and that the appellant has raised. The second exception, and this Judge May also articulated, encompasses a safeguard to prevent that sort of windfall. That safeguard is that the enjoined party has to expeditiously move to dissolve the injunction. And that's been the case in every single case that's espoused the second exception to the general rule. Here, we don't have a case of foreseeability because we're recovering only attorney's fees, which are quintessentially the most foreseeable of damages that the moving party could have imagined would be incurred by the enjoined party. And two, the employees moved expeditiously to dissolve the injunction. In the briefs, we compared the times, and I believe it was 10 days here from the entry of the injunction to their motion to dissolve. In the Andrus opinion, it was 9 days. In a couple of other cases, it was 10 and 16 days. So there's a safeguard in those cases, and that safeguard is exemplified by the facts here. To continue the analysis, in the Andrus case, Judge May said, we're dissolving this injunction on its merit. And I've determined that bond amount is essentially tantamount to no bond at all. We're not going to hold the party to it. So if we were to follow the step-by-step procedure adopted by the Florida Supreme Court in Parker Tampa 2, we would remand the case back for an evidentiary hearing on foreseeable damages. But since we're just going to dissolve the injunction, we might as well allow the enjoined party to present evidence as to actual damages incurred. And I contend that's the position the trial court found itself here. It dissolved the injunction, realized that the bond had not been posted, and it allowed the enjoined party to recover the full extent of the damages it incurred. In this case, it was simply just the attorney's fees that were necessary in order to dissolve the injunction.
VPX is relying on the Ross versus Champion case, so there's some language in there that certainly is adverse to your position. So
Without
I'll give you a
doubt.
chance to address that.
That case predates the development of this exception that was relied on by Judge May and the subsequent cases to the Parker Tampa 2 case. I think I said earlier that those cases stated that there was a conundrum left unaddressed by Parker Tampa 2, and Ross came at a time before that conundrum was acknowledged by the jurisprudence. I think Ross was decided in 1991. Most of these cases came in the later parts of the 1990s and then the 2000s, and most recently 2 years ago with this court. Moreover, that comment wasn't the holding of that case. It was essentially a comment on the existence of the jurisprudence, which at that point in time, since there was no additional case law discussing this exception, was just that a party would be unable to recover its fees. Counsel also mentioned the Shea case. The Shea case said that the bond is the sole source of recovery following the dissolution of an injunction. But we know that's an inaccurate statement where you can surpass the bond when there's been a lack of an evidentiary hearing. Those two cases essentially are significant from a historical standpoint, but they are no longer of legal effect today. And I guess unless there are any questions as to this issue of entitlement, I'd like to move on to the second one. And the second issue, counsel has contended that we should ignore the typical attorney's fees model in this assessment of damages. And we should essentially calculate damages based on how much money came out of your pocket during this injunction period. There's no authority to support the conversion of attorney's fees to damages under the statute. Because the parties agreed that attorney's fees are recoverable under the statute, the trial court imported the rubric from a quintessential attorney's fees model into the case. And it did so by bifurcating the proceedings, first holding a hearing on entitlement, then holding a second hearing and eventually a third hearing as to the reasonableness and the amount of the fees. I would contend that this argument, second issue as to entitlement, is a legal issue that was required to be raised at the initial hearing on entitlement. It was not. The only argument that was made was the first one that the opponents raised today. And in their motion for reconsideration, which was filed after the depositions that referenced possible third party furnishing the attorney's fees here, that motion did not contain the legal argument either. First time it was raised was on the hearing to determine amount and reasonableness of the attorney's fees. That point in time, the trial court was set to just hear evidence as to the trial lawyer's rates and the amount of time expended. It's not the proper time to bring that argument. Second, even if this court wishes to reach that argument, I'd contend again that there's no authority for that proposition, that we should essentially convert the typical prevailing party fees, attorney's fees model, and make it into an out-of-pocket expense. I'd refer the court to one case, and this is the only case I've seen that's on point. It's the third DCA's Leibowitz case. This is a significant case because there the city was the enjoined party, moved for fees following a wrongful dissolution, similar to the case here. And the enjoining party argued that the rate shouldn't be calculated at the assistant city attorney's reasonable rate in hours, but rather its salary. How much money did the enjoined party have to pay for the services of its assistant city attorney? There, the third DCA reversed the trial court and stated that we should preserve the traditional attorney's fees model and preserve the normal attorney's fees calculus following the dissolution of a hearing. Respectfully, I see no other authority indicating that we should treat it any other way. So a little early, but if there are no further questions, I'd respectfully request the court affirm the final judgment of damages in all respects. Thank you.
Thank you.
The authority that opposing counsel can't find is found in section 60.07. It says the court may assess damages to which a defendant may be entitled. Damages are expenditures that were suffered by the enjoined party, and if they didn't pay any fees and had no obligation for fees, they hadn't proved their damages. It's a failure of proof whether or not they had entitlement. The other cases that he cited at the outset of his argument were cases where a bond was erroneously set. And often those cases involve an ex parte injunction where a court just arbitrarily picks a number which is challenged on appeal and which is proven to be unfair because the other party, the enjoined party, had no opportunity to present evidence. And so there's a reversal. It's challenged on appeal, it's reversed and remanded, and if the injunction remains in place, then the court remands for entry or for conduct of a hearing to determine the right amount. Those are different cases than we have here, because here there was a bond, it was flawed, it was challenged, and it was remanded to fix it. Here we don't have that because there was no bond. And nothing in their brief, nothing in our research supports the notion that a private individual may recover damages for a wrongful injunction in the absence of a bond. It is the very purpose of the bond, and any other decision would eviscerate and completely render meaningless the bond requirement in the rule, the damages statute, and the non-compete statute. So this court should reverse and hold that, consistent with Parker, Tamper 2, that no damages could be awarded in this case, either as a matter of law or for a failure of proof. Thank you.
Thank you all. Have a good day. Court is adjourned.
All right.